Hey, good afternoon, everyone. Welcome. Thank you for joining us. I'm Christine Sauve, the Policy Engagement and Communications Manager at the Michigan Immigrant Rights Center. Today, we're talking about language access. So before we get started, I'd like to go over a few housekeeping items so you know how to participate in today's training. We will present the information first and then answer questions at the end. If you have any questions along the way, please put them in the Q&A box so that we can see them when the Q&A portion starts. We're excited so many of you could join us today to learn more about language access and the laws protecting our rights to have important information in a language that we can understand. MIRC and several of our partners worked very hard over the course of 10 years to advocate for a state language access law, and we finally achieved that in November 2023. Thanks to Rising Voices and MIPODER for their help in getting that passed. Now that the law is in effect, we want to make sure that everyone understands what it does and does not cover. Also, a note about the language of today's presentation. We had opened the option for requests for interpretation, but we did not receive any requests. However, we do know that operating solely on requests for interpretation is an imperfect process. So we plan to record today's presentation separately in Spanish, along with translated slides, and we'll make that recording available to the community very soon. If you'd like to work with us to make the information available in other languages, please let us know. And now I'm going to share just a little bit of information about MIRC, if we can pull up our slides. So for those who aren't familiar, the Michigan Immigrant Rights Center is a statewide legal resource center for Michigan's low-income immigrants. We provide free immigration legal services. We work to change unjust laws and policies. And we provide community education and training on topics related to immigrant rights. On the next slide, you can see that we assist people with naturalization, survivors of domestic violence and crime, unaccompanied children, asylum seekers, and you'll see our general intake phone number on the left. We also serve farm workers regarding issues related to employment, and you'll see the phone number for people to call on the right. And at the bottom, you'll notice one more number that people can use to call us because we also assist folks in detention and facing deportation. All right, and to our next slide today, this is just a brief overview of our agenda. We'll talk about what language access is, review federal, state, and local laws, and dig into Michigan's new language access law. Then we'll answer your questions. So now, without further ado, I'd like to introduce our presenter today, Ellie Jordan. Many of you know Ellie from her many years of excellent work here at MIRC, and she is now at our sister agency, the Michigan Poverty Law Program, working as the public benefits support attorney. And with that, I'll pass it to Ellie.
Thank you so much. We're really excited about this meaningful statewide access to language services law, and we're so excited that so many people were eager to join us in this training today. So we want to get started by just testing our own knowledge. Sometimes it helps us to sort of cement our knowledge to see what we know when we start off. So let's take a few minutes to answer the questions that pop up in the poll. And I know my colleague Moises will get that poll up for people. Are people able to see it though? Can anybody give a thumbs up? Okay, just making sure. Popped up on a different screen for me. So take a moment to look at the questions there. Try your best at the answers, and we will talk through the answers after this and throughout the presentation. I'm glad I see about half of you have responded. If anybody wants to take another minute and quickly just put in your best guess, and then we can move forward. All right, I think we'll go ahead and end the poll there. I see a great number of people participating. Excellent. So let's look at our questions and our answers. So starting with the basics, true or false, if someone does not feel comfortable speaking English, they have to bring their own interpreter to help them when they go to a state agency for services. And this is false. A new state law and federal laws require meaningful language access at all state agencies and entities. So true or false? If someone uses an interpreter provided by the state agency or entity, they will be sent a bill for those services or be billed in the moment. And that's also false. Services must be offered at no cost to the individual who requires the language access. And then if we keep moving through our questions, we see true or false. State agencies must provide important documents and website tools in languages other than English. And the answer there is true. All documents that are referred to as vital documents must be translated into needed languages. And we'll dig into that further as we go forward. And then a final true false as we go through. When a person goes to a state agency and there's no one available to interpret, there's nothing that can be done. They just have to keep coming back until someone is available. And this is false. Agencies must provide this resource in most cases, so the user could ask for a supervisor if they're not given access because of their language needs. If necessary, a user could file a complaint if they are not able to meaningfully access services. So kind of recapping our questions and our polls, thanks so much for getting into that exercise and testing our knowledge from the get-go. Government agencies are required to provide professional, competent language access to people who struggle to access services because they're not comfortable communicating in English. And users should not have to pay. Users should not have to provide their own support person to interpret or translate. And if you or a person you are working with experiences a barrier to services, or has to provide their own interpreter or translator, then they may be able to complain to the federal government or the state government to make sure that that doesn't happen to others in the future. So let's dig into these laws, shall we? Let's start with just an overview of some basic specifics that come through in all of these. And you may hear me misstate some of these words, but we'll get clear on this at the start. Translation, when we talk about translation, that refers to written content, whereas interpretation refers to oral language services. If somebody were speaking while I was talking, that would be interpretation. Both federal and state governments require language access. State and federal agencies must provide language access, and a government agency is part of a government that is responsible for a specific area of study. So if we talk about an agency that's a part of the government that's responsible, like responsible for a sector, a field within a government, and these agencies can be at the local, state, or federal level. An example of a federal agency might be Social Security or Veterans Affairs. A state agency might be the Michigan Department of Health and Human Services or Labor and Economic Opportunity. So these are all different examples. Now, federal funding can require language access even at the level of a state entity or another entity that receives federal funds. Federal grants or contracts often come through agencies to nonprofit organizations, so that spending power is one way that the federal government can make sure that those who are doing this work do it in a particular way. and in keeping with language access. So when we say LEP, or limited English proficiency, as used here, means people who experience the inability to understand or effectively express themselves in spoken or written English in connection with their national origin. And that derives from the definition that came through in the state law. So charging forward, let's get into the federal requirements that lay the groundwork for this. Title VI of the Civil Rights Act of 1964 is a federal law that prevents discrimination based on race, color, or national origin in programs and activities that receive federal financial assistance. So Title VI applies to recipients of federal financial assistance such as states, universities, local governments, um, all kinds of different entities that get those federal funds. And it prohibits discrimination in the following ways. So you cannot exclude people from participating in programs or activities. You can't deny people the benefits of programs or activities, subjecting people to discrimination in programs or activities. And for a good example here would be if a local welfare office that assumes a person's citizenship or immigration status based on just their surname, an accent, or difficulty speaking English, that would be all in violation of Title VI. So this began to be applied um, in, um, in a really helpful way in 1974, when an important Supreme Court case, Lau v. Nichols, clarified that not providing language access to Chinese-speaking children in a school setting violated Title VI because it made a barrier that was related to national origin. So these children who were non-English speakers or were not completely comfortable speaking in English were denied a meaningful education. And this language barrier was related. The court really highlighted and identified this link between the language barrier and national origin. And so the Supreme Court found that this would be a violation of the Civil Rights Act of 1964. And so as this continued through the decades and needed more clarification, we had a 2000 executive order by President Clinton, who issued this order that sets out how U.S. agencies and anyone who receives federal grants should make sure they're not violating Title VI or Lao by providing meaningful language access. And so this executive order number 13166 was signed in 2000, and it really grounded its decision making in the Civil Rights Act and Title VI. This applies to agencies that receive federal funds and all programs and activities of federal agencies. So it requires that those federal agencies provide meaningful language access to LEP individuals. And agencies must take what it referred to as reasonable steps. This is really shows that they must examine the services and identify what LEP needs would be within those services and develop a written language access plan. So Michigan's language access laws incorporate and refer to this executive order, and the Michigan legislature directed that its law be read in the spirit of the 2000 executive order. So continuing to move forward through how these laws have rolled out, more recently in 2025, President Trump issued Executive Order 14224, which rescinded 13166, the Clinton order that we were just discussing, and purporting to state that it was making English the official language of the United States. Now, Executive Order 14224 rescinded that order and designated English as the official language. But it did not actually change federally provided services. There's no requirement. It specifically identifies that the agencies are allowed to make individual decisions and may still offer non-English language services, and it has no impact on state law. Further, an executive order cannot overrule the Supreme Court case, law, or regulations that were enacted consistent with the Title VI rules and consistent with law. So while 14224 states these things, it does not require changes within the federal agencies and does not override the existing regulations or the existing case law that does require language access and has no impact on state law. Getting to Michigan's new language access laws. In 2023, the Michigan legislature passed the Meaningful Language Access to State Services Act and the statewide Meaningful Language Access Coordination Act. So these laws are intended to bring all state-provided services to the same level of language access that the federal rules, specifically the Clinton era 13166, require, and those implementing the standards that implemented that. The Michigan State Legislature's law went into effect in February 2024, and implementation is beginning and ongoing. It's a large process, but has been rolling out. As we look to the specifics of these laws, it's sort of broken down, as you can see, in two big parts. There's the Coordination Act that explains how the Office of Global Michigan, which is housed in the Labor and Economic Opportunity Department, should organize other state agencies. So it's sort of running point here. The other agencies to provide language access and allows for complaints. And then the Language Access Act details the reasonable steps that must be taken to provide language access and prohibits charging individuals who need those services for the service. So what must state agencies and departments do under these laws? All state entities must provide meaningful language access, which is defined that meaningful language access is really set out as meaning the ability to receive information and participate in and benefit from public services. So it is not just to give lip service, it really is to provide access to these services. So when we look to how language access is to be made meaningful, we start with oral language services and interpretation. So oral language services should be provided through face-to-face, in-house, so an employee or staff member within the agency, or telephonic means, a virtual interpreter. This must be provided by individuals with demonstrated competency. So it provides some flexibility with that, but it must be someone who's able to be competently interpreting the subject matter that's at issue at that agency. Relatives, this is a really important point. Relatives, friends, bystanders, they don't substitute for a competent person. However, if the person who receives the services and requires interpretation would prefer a relative, a friend, or a bystander to help over the professional person with demonstrated competency, because for whatever reason they feel more comfortable with that, that is permissive, is permissible. But It has to be they have to desire that the person receiving the services. It can't just be that it's more convenient for the agency. It must be that they request that. There must be oral services available based on the area served. So that goes to the specifics of what languages are pertinent there. And there will be more detail on that soon. And people cannot be asked to pay for the oral language services in particular. So we go to translation. Specifically, vital documents should be translated. So at a minimum, if 500 or more people are served by a local office or 3% of the overall population within a geographic area is served, then that language should be pertinent to the those documents. Documents that are vital should be translated into those languages that apply to those standards. And what makes a document a vital document? If it provides important information that's necessary to access or to participate in services, programs, and activities of a covered entity, including but not limited to any applications, any outreach materials, and written notices of any rights or denials, losses, or decreases in benefits or services. So, vital means whatever sounds like it would be important. If you can't meaningfully access the services of this agency or entity, then then that is going to be something that's going to be vital. So who should benefit? The law goes to who are individuals with limited English proficiency, which the state defines as the inability to understand or to effectively express oneself in spoken or written English as a result of one's national origin, and the individual has not developed fluency in the English language. So, notably, reaching back to the roots of all of this in Lau v. Nichols, it didn't necessarily involve children that were born in China, but people of Chinese ancestry. So it doesn't necessarily, when we talk about it being as a result of one's national origin, that doesn't mean that if someone was born here in the United States, they wouldn't qualify. It's the overarching need for that language access extends. And it's important to know that this tool can really this is to complement other laws that also require access, such as the Americans with Disabilities Act, other state laws such as Elliott-Larsen, and other laws that are there to protect against discrimination on the basis of national origin, against other forms of discrimination, and importantly, there's other laws that really provide access when a difficulty in communicating or understanding has more to do with a disability. So these should complement one another, and they may appear together. And so advocates and anyone who's paying attention to this should really be looking at how to use those together and have them complement one another rather than supplant one another. So let's look at who should provide that meaningful language access. And we've talked a lot about the state agencies, but the law does go a little bit more broad and has more coverage, the state law, than that. Covered entities include state departments, agencies, or any entity. So this means state government agencies, as we've been discussing, such as the Michigan Department of Health and Human Services, but also smaller divisions, boards, or task forces could be considered state entities. This is, rolling out. But a court would likely look at the totality of the circumstances. So considering everything, what makes it an entity? Things like the funding, how much control the state exerts over that entity, or that board, and then who is a member. So there's a lot of boards and committees that are sort of required under state law and highly regimented. It would be interesting to see how it will play out, but these could technically be covered entities. It's not limited only to the top level agencies. And then don't forget that when this is just the description under the federal under the state law, the newer state laws. But when we think about federal law and the reach of federal funding, it reaches a lot more organizations and entities that receive that federal funding. So who oversees language access? The Office of Global Michigan, as the Coordination Act sets out, has a language access coordinator and who is working across state government to bring these entities together. And each covered entity will designate a language access liaison. That person may have other tasks and other things under their job description, but among those other tasks, this has to be one of the things that they are ultimately responsible for when it comes to that particular entity. So every 2 years, these covered entities will report on what steps they are taking to comply, including how many bilingual staff they have, the training, their staff training plan, how they will let the public know about their language access services. And you can find a list, there's a screenshot of it on our slide, but you can find a list of the contact information for each agency's liaison on the link there. And I believe that's being shared in the chat. So each department is responsible for creating a language access plan that is compliant. And soon we are hoping to see and looking forward to see translation right on the web pages so that those vital documents of the actual web page explaining these language access plans and who the coordinator is will hopefully have translation available in coming months, hopefully. So jumping back into the considerations under federal law, there is a mechanism by which you can file a federal complaint if a federal agency or federal grantee is not providing the language access that they should. So remember, kind of any agency that receives federal funding must provide meaningful language access. And if you or someone you're serving experiences a barrier to access connected with language access, then you could ask whether the program receives federal funding, and if so, file a complaint with the Federal Office of Civil Rights. You could ask the person in charge of language access for the state agency or any agency that receives federal funding from the list on on the website. And then even if you're not sure about funding, you could attempt this step and make sure that language access is highlighted. Um, and you don't need, some people's privacy is obviously of utmost importance. So it's helpful to know that you don't need to provide your name and address. And if you do, the Federal Office for Civil Rights states at this time that your information will only be used to investigate the complaint and not for any immigration enforcement or other purposes. But those options are available. When we look at the Michigan complaint procedure, if you or someone you're serving experiences a barrier to access connected with language access through a state agency or something that seems to be connected to the state, then you can complain to the Office of Global Michigan regarding customer service problems or poor interpretation or translation experiences. soon, we're hoping to see that translated forms will have a feedback section where someone could provide corrections, even without filing a formal complaint, sometimes contextually or different details of interpretation or translation can be commented on without going through the whole process. But the complaint process is quite simple and will help to make sure that each issue that is experienced really comes to the attention of the appropriate people. And then there's also the option to file a complaint with the Michigan Department of Civil Rights. This you would do by filling out the online form or calling the number that I believe is on the screen, but it's 1-800-482-3604. The online form is currently only available in English, but we can show you in a moment how to use AI to get a rough translation in your browser. And then you can also call and leave a message and use your language because the language access law also applies to this department. So to be clear, both types of language access failures are violations that emanate from national origin discrimination. Regardless, you have two options for making your complaint to the state of Michigan, and you can do one or you can do both. This is in addition to the federal complaint option that we discussed earlier. These all are available to people, and state complaints are more likely to yield a quick resolution or improvements. So just another quick note, the Office of Global Michigan would encourage complaints to be submitted within 180 days from the date of the incident to ensure a prompt investigation and a resolution. So getting those in sooner rather than later is helpful. However, there's no time limit situated that's in the state language access law. However, really importantly, there is a time limit for submitting complaints to Michigan Department of Civil Rights, the MDCR. Under state law, an individual has 180 days from the date of the harm to file a complaint. So moving forward within 180 days would be really best practices, if at all possible. But that information is helpful whenever it does come. So be sure to put in that information so that these services can continue to get better and better. So just a quick sort of life hack that is really helpful. The you should sorry, I lost my spot here. This slide explains how you can go to the translate dots in the top of, if you're using a Chrome browser in particular, and make sure that anything that you need translated, just a website in the meantime. This can be helpful for any number of things, but for the time being, the main landing page where the complaint form lives is available in English, and again, translations are forthcoming, but using this in the meantime can be very helpful. So going up to the upper right corner of your screen if you're in a Chrome browser, and you can choose the translate feature, and that way you can get that in at least the AI version, the artificial intelligence version of your of the language you choose for the moment. So there it is. The form itself is available in multiple language, but the language access landing page is not. So once you get through this part, you'll be able to get to more languages. And again, fully language accessible landing page is coming soon. It's in the works. So this is what the complaint form looks like on the website currently for the Office of Global Michigan. You can see from the very top right, you can click down and get multiple languages. Um, I think all of these links are getting placed in our chat so that you have easy access and you can bookmark them if you need to. So that's what the form is, really pretty straightforward as well. So kind of seeing it will help you. Even if you were to scroll down, it's quite a simple form and can be done in just a matter of a few minutes, probably. Um, so you should also be aware that there are other entities separate from state government that provide language access. So remember, any entity that is receiving federal funding should be providing that language access. So some cities or counties have language access policies or programs, for example, the city of Detroit. And so becoming familiar, if you're in a particular area, becoming familiar with the language access plans that are on the books already and looking for ways to improve those is always a great way to serve your community. And many local law enforcement agencies use telephonic interpreters. Police and sheriff should be using their own language access services and should not be calling places like Border Patrol in order to provide interpretation or translation. Courts also have their own language access plans, and the state courts have their own plan. Um, and so each of these entities is charged with providing language access. They just have different aspects that they're impacted by. And many healthcare facilities have language services, but sometimes individuals really need to assert their rights to these. But the funding is really important to this. Funding does require that access. So we have covered a lot in this presentation. I hope it was helpful to you. And there is a link to a handout that sort of summarizes a lot of this in the chat. I really enjoy talking about language access, and we could even speak a lot longer probably about all the details. But just kind of quick recap of the important top line things we want you to take away. Um, we do have a new state law, plus existing local and federal laws that require meaningful access to services for people who are not proficient in English. Vital documents must be translated into the needed languages. These services must be offered at no cost to the individual who requires the services. And if individuals do not receive these services, they should file a complaint, and those who are helping them can assist them if they are not able to meaningfully access language services. Um, so those complaints are available again at the federal level and then through the Michigan Department of Civil Rights, as well as the Office of Global Michigan. We did have some really great questions from participants, so I want to turn that over to Christine to share out some of those questions.
Great. Thank you so much, Ellie. Thank you for that extensive overview. We know that was a lot of information, but we have a little bit more to share via some of the questions we've received. So some of them I've answered already, and we got some in advance. So there was a couple questions about, is there a model language access plan people can use? Do the departments include things like needs assessments? So the department language access plans are being developed. Most have a language access plan from what I understand now. There may be some that are still finishing theirs. The language access coordinator for each state department or agency is in charge of that. and then they're coordinating with the Office of Global Michigan Language Access Coordinator. And those plans can cover a number of factors. That lep.gov resource is very helpful for that. There's typically 4 that are recommended. So looking at the number or proportion of LEP persons who are served, the frequency that someone uses the service, the importance of the service, and then the resources or the staffing or funding that is available to meet that need. So those are all some of the components that go into a language access plan. There was a question about how to let organizations know that they're violating language access. So for nonprofits, for city and county governments and healthcare organizations, they would each have their own unique complaint process. So you can usually find those on their website. For nonprofits, they may not have it posted, but you could contact someone in administration. And if they receive federal funding, you can always submit a federal request in addition. If it's a state agency complaint, then you can use either the Office of Global Michigan complaint form so you can submit one there and also to the Department of Civil Rights if you so choose. There was a question about requirements for becoming an interpreter in Michigan. So under state law, the only requirement is that the person providing language services has demonstrated competency in the appropriate language. And this is a more flexible standard than what's required for the courts. And most vendors are responsible for conducting the assessments. Competency is important, but the flexibility should also allow more people to enter the interpretation field without prohibitive testing rules. And that may be more appropriate than in court where exact accuracy is highly critical. For federal healthcare for healthcare organizations, I just want to flag that there are federal healthcare regulations that are more specific. For example, the rule states that being bilingual alone does not mean an employee is qualified to be an interpreter, and interpreters must be familiar with any specialized vocabulary and terms. We had a question about the legal status of language access nationally. So we did address that in terms of, the executive order question. However, the statutes, the civil rights law remains unchanged. That is still in place. And so a number of states have additionally passed similar state language law access laws like Michigan has. And then additionally, many local governments across the country do as well. Let's see, I think we talked about that one. There was a question about, does the law require all public health providers to use interpretation? And how can we report those who do not? And what are the laws about access to interpreters in healthcare? So again, that federal civil rights law, the guidance for recipients of federal funding, and then there's also new provisions in the Affordable Care Act. I can put that link in the chat that also stipulate requiring language access. So all aspects of the entity's health activities are subject to those provisions if the entity receives federal funds. So for example, if an issuer sells plans on health insurance marketplaces, then like healthcare.gov, then they're covered, including sales of plans off of the marketplaces. It also prohibits discrimination in telehealth and by subcontractors of federal fund recipients. And then how can language experts be most useful? It'd be helpful to, harness knowledge from language experts about nuances between dialects and prevalence of languages, why certain things cannot translate well, and why someone who speaks a more common language as a second language, shouldn't be pressed to use that language rather than their best language. All of that feedback is helpful to language access coordinators, I would say. And that information can be incorporated when departments or agencies are creating their plans. I'm going to pause there to see if any new questions came in. Would this law apply to a private practice setting that is not receiving federal or state funding, such as Medicaid or Medicare? So the state law would not apply in that setting. The state law covers state entities, and then the civil rights but the Civil Rights Act still exists. So Ellie, I don't know if you have anything to add to
Well,
that.
it would be it'd be pretty difficult to find any healthcare providing entity that's so separate. I can imagine some private entities that provide maybe less common procedures or things like that. But really, if they accept insurance from, for example, the healthcare.gov marketplace of any kind, even like the ones that people are paying into, they would, if they accept any of that, my understanding of the regulations is that it applies to their entire practice. And so I think it would be it would behoove people who are experiencing barriers to alert the at least assert rights, and say this is a right that should be covered. And if it would be unlikely that, especially in a healthcare context, that somebody would be so private that they're able to avoid all of this. But it's possible that the question is a possibility.
Thanks, Ellie. Is there an electronic setting for immediate translation for state agencies? So you'll see some pages that have a feature sometimes where they'll set up a translate option in the upper right corner. I don't believe every state agency page has that, so selective. Some of that is based on language access planning and which pages are where that's most needed. But if it doesn't exist, you can always use that trick that we showed today in the Chrome browser. Um,
And it is
and
my understanding that more proliferation is definitely in the works and is a priority of the Office of Global Michigan.
yeah, so you'll probably see more of that rolling out. But if you don't and you need it, then, again, use that complaint form, especially, to the Office of Global Michigan. They can communicate with that department or agency's coordinator and help get that resource up and running. I used that feature recently. There was a document by the Michigan State Police we were looking to have translated. We made the request and got the document translated. So it is working. But the state government is very large, so there are probably places where it may not be applied yet. So please do feel free to reach out to either the Office of Global Michigan coordinator, or you can look on that page for the list of coordinators at the bottom for each agency, if you want to discuss some of the materials with them. Let's see. If there is, for example, okay, is it a violation if, for example, a Mayan language speaker in the agency only offers Spanish, even though it's not the client's first language? Ellie, I think you touched on that, but do you want to elaborate more?
So the language access law does prioritize availability of languages that are more commonly spoken, but a person should have the ability to speak their best language, particularly the oral interpretation services. And so that a very, very um, uncommon language, it may be a little bit more difficult and take a little bit more time to identify someone who can provide capable interpretation services. However, a person does have the ability, especially particularly for the interpretation, to be able to communicate in their best languages. So that's how I would come at it and sort of assert like this is my best language. And this is where I think it would be critical to continue talking with language experts to help explain why it can be difficult for people who may be highly proficient in say Spanish, but really grew up speaking maybe Ixil or a dialect to be able to fully express themselves, especially in more detailed contexts in those languages. People are incredible and have become very flexible, but for some purposes that really doesn't work well. When it comes to translation of vital documents, that will be a little bit less likely to automatically occur in less common languages because the calculation does have to do with the number of people and the percentage. But the state law also paves the way for a state agency or a state entity to identify needs of their community. And so this is where community participation would be so critical to come forward and share, this might be this language may not hit one of those statistics. However, it's really needed. And if they hear about that, then that would be more likely to be met because if the agency becomes aware, then they have that permission to go in and do the translation of those documents. So I think I am eager to have people read these laws as people should be able to communicate in the language they best communicate in. And let's advocate for full-throated application of that and worry about the details later that's what I would say.
Okay, a few other questions here. How does an individual know that the agency gets funding from the federal government?
That can be it can be difficult to spot right off the bat, but you can also ask. And so I think that's a perfectly fair question. And anybody interacting should be able to note that. There's it may be that you'll be able to see on signage or something on a website or something like that about funding sources. Sometimes it can be a little bit more tricky. If you want to really dig in, you can review the federal agency that you think might be a funder and look to lists of grantees. But the simplest way would simply just be to ask. And that can get you a long way usually.
And again, you can find those department coordinators on the main landing page. Let's see, there was a question about will we have the handout in Spanish? Yes, the translation has started but not finished, so watch for that soon, along with this recording in Spanish as well. Are Dari and Pashto languages not included, or are they available in the language services in most places? I can't remember if it's already listed, for example, as one of the options in the complaint form. It may already be there. But that language would be covered just like any other language. So again, if 500 individuals or 3% of the service population for that department or agency, they would also be able to ask for those translations or interpretations in Dari or Pashto. Guadalupe is just clarifying. I think I said Office of Global Michigan Coordinator. The statewide language access coordinator is based in the Office of Global Michigan, but there's a separate Office of Global Michigan language access coordinator just responsible for the Office of Global Michigan's language access work. So if you have an issue with any of the departments or agencies statewide, the correct term is statewide language access coordinator. And then if you have an issue specific to the language access failures happening in the Office of Global Michigan, then there is a coordinator in charge of the Office of Global Michigan's language access plan and making sure their services are in order. So thanks for that clarification. Let's see. Yes, folks will get a recording. I'm going to post the Office of Global Michigan Language Access page in the chat again. There was, let's see, I think one more question here. The landing page, if it's only in English, how do you translate that using the three dots? If you go back to, you'll see the slides, it shows you to navigate to the top right corner in the Chrome browser. Oh, thanks, Ellie. And that can help you get a quick rough translation. But as we said, they are working on having that fully translated, so watch for that rollout soon. Okay, I think we're coming to the end here. I think there was, again, a question about the executive order. Does it have an impact on on language access besides creating a perception of limited access? So again, it does not change the Federal Civil Rights Act. It does not change existing case law. It does not change, it doesn't affect state law. It doesn't change existing federal regulations. And it has not directed state agencies to not offer language access. It is just said that it is up to them. So yes, it does create more of a perception than any actual changes at this time, but we will be watching that. With that, I hope we answered all of your questions, but if not, Ellie, if you could go to our last slide and folks can see how to get a hold of us if they have any questions for follow-up. And again, the Office of Global Michigan is also a great resource. So the statewide language access coordinator is also someone that you can reach out to. So with that, thank you everyone for joining us. Really appreciate your interest in helping ensure that our community members have meaningful access to essential services. Keep in touch, feel free to reach out, and you can also reach out to the Office of Global Michigan. Thanks everyone. Have a good afternoon.
Thank you.